Welcome to the Pure Legal Guidance Podcast, where we discuss current events and legal subjects. This podcast is presented by Parlatore Law Group, a nationwide cloud-based firm that cuts down on overhead expenses typically associated with traditional brick-and-mortar firms, allowing us to pass that savings on to our clients. We provide high-quality legal services that are accessible and affordable, while freeing up our attorneys to focus on what they do best: provide pure legal guidance to our clients.
Hello and welcome to the Pure Legal Guidance Podcast by Parlatore Law Group. Today I'm joined by Matthew Hefti and Maryam Hadden to talk about the recent decision in the Bill Cosby case. So what I've done is I've assembled this panel here. Maryam has spent a significant amount of time as a prosecutor, both in the trial and in the appellate side of things. Matthew has spent a lot of time in the criminal defense appellate side, and I've, of course, spent some time in the criminal trial side. So we wanted to kind of go through this decision and analyze it for you. So before we do, let's kind of give a brief overview. And just to be clear, we are not making any statements during this podcast as to whether we believe that he is innocent or guilty, because ultimately what we're talking about here are the legal issues. Is he guilty? We don't know. One jury said that he was, based on the information they had. Another jury said they couldn't be sure based on the information they had. And ultimately it's murky enough that we're not going to address that. But instead we're going to go through some of the legal issues, which haven't been covered as widely. So reading the decision here, what the court was looking at was really a decision by the district attorney's office back in 2005 not to prosecute, and how that impacted the trial today. So first of all, let's go through kind of what happened back then. And Maryam is the former prosecutor. Can you kind of explain what was the DA looking at back then, and why would they have made the kind of the decisions that they did?
Sure. So a district attorney has a tremendous amount of discretion in the decisions that they make. It's up to the district attorney to decide what charges to file, whether or not to file charges at all, essentially whether or not to go forward with a case. Now, there's some limitations on that depending on whether or not a grand jury is involved, but the initial question of, is this a case that we want to pursue, is really within that district attorney's discretion. So back in 2005, the then district attorney in Montgomery County was looking at evidence from interviews, looking at the victim who had waited about a year to come forward, and I believe had initially actually contacted a civil attorney before reaching out to the police in her native jurisdiction, which then contacted this jurisdiction. So he was looking at that. He was looking at evidence from detectives. I believe he spoke with the attorneys who were representing Mr. Cosby on the criminal side, not necessarily on the civil side. And having looked at all of those things, he made a determination that in his independent judgment, he didn't believe there was a strong enough case to go forward and establish Mr. Cosby's guilt beyond a reasonable doubt. It doesn't mean that there was no evidence. It just means that his evaluation of the evidence was, this is not a case that's going to be an easy win for me at trial. And his evaluation then was to say, I have difficulties with this as a criminal case, but as a civil case, that may be the victim's best route forward. So what he did essentially was try to help out with the civil case by issuing a press statement, and a very public signed press statement, saying the district attorney's office is not going to be prosecuting this case. There will be no criminal charges. And essentially, it's up to you whether or not you go forward civilly. A lot more detailed than that, of course, but that was the gist.
Yeah. And that statement is really kind of the essence of this whole thing here. And just for historical reference, at the time, you hadn't yet had a whole bunch of women that had come out to say, he did this to me too.
Correct. At the time, he was really evaluating the case from the standpoint of having a single victim. He had actually made an announcement that they were looking into Mr. Cosby, which, theoretically could have gotten some other women to come forward and didn't at that point.
That's right. He did make a press release right in the beginning saying that they were doing the investigation. I mean, is that something that DAs sometimes do in an effort to try and see if other victims do come forward?
In this kind of case, yes. It's this is sort of a unique situation because you're talking about a very high publicity public figure. It's not something where it's just, an allegation against the man down the block. This is a very well-known public figure. So in that type of case, yes, that's absolutely the kind of thing that, a district attorney might determine to do, again, in their discretion, is to put out that kind of a, almost feeler to see if there's anybody else out there who's going to come forward.
Right. And so ultimately the decision that he came to make an announcement that they would not then and did not ever intend to prosecute Mr. Cosby, that had significant effects on the civil case, because in a criminal case, you have a Fifth Amendment privilege not to incriminate yourself, so they can't force you to testify, they can't force you to be questioned. But on the civil side, the Fifth Amendment doesn't necessarily apply, where they can force you to testify, they can force you to be deposed. But if you invoke your Fifth Amendment right not to answer questions, if there's a reasonable belief that you could face criminal prosecution based on those questions, then they can't force you to answer the questions.
Right.
So essentially they can force you to get up on the stand, but you could just sit there and plead the fifth to every question.
Right.
But in doing what he did, by making a very strong, binding statement of we will never prosecute him, that removes that one element, because now there's no fear of him ever being prosecuted, and so therefore now he doesn't have a right to refuse to answer the questions. So the civil judge could even compel him to answer at that point, or threaten him with contempt.
Correct. It basically narrowed his options in a really significant way in terms of the civil case. And I believe at the time that he issued the press statement, the civil case had not actually been brought yet, but everybody was aware that it was coming down the pike, so to speak. So he made that announcement with the express intention of aiding the victim in her civil case.
Sure. And of course that became, really the crux of a motion that was made when he was then arrested later on, and then ultimately was what brought it to the Supreme Court in Pennsylvania. Correct. To overturn it. So, so Matthew, you have a lot of experience with criminal appeals. What do you think about that process of how it went up on the appeal?
Well, I think that it probably would have ended up in the same position regardless of how the lower courts decided, whether they would have decided the same way that the Pennsylvania Supreme Court decided, or whether they would have suppressed the information earlier or gotten rid of the conviction earlier. I think that it still would have ended up in the Pennsylvania Supreme Court, because the issue is so rare, so factually unusual, and the question of law presented was so narrow, or at least the question that it was decided on, that I think it would have ended up there for primarily two reasons. One is just the legal issues and the novelty of the question of law, but two, the high-profile nature and the resources available to Mr. Cosby. When you have a client who can pay, it's much more likely that that client is going to do everything that they can to, protect themselves or try to right a wrong, or to get justice equally as the, Constitution gives us, that privilege and right to have equal protection under the law. And so when a client has resources to use the courts, I think that's why it would have ended up here anyway, in some manner. So in terms of the process going up, I think that the Pennsylvania Supreme Court got it right, and that the district court didn't necessarily get it right. But I think that the legal question was correctly decided by the time it was said and done.
You know, you bring up a great point about the resources of the defendant, and you know that's kind of how I frequently look at the justice system, and where they say that they have, you know, two justice systems, those for the haves and the have-nots. You know, that's really true. And in fact, there was something, Mary, you and I were talking about even earlier today, where he went to trial twice on this. And the first trial, the jury was deadlocked. They were unable to reach a decision, so it was a mistrial. And the district attorney decided to try the case again. And Mari and I each had separate opinions on whether does a retrial favor the defense or the prosecution. And in a lot of cases, it comes down to exactly what you just said, Matthew, where a defendant spends all their resources on that first trial, and then when they go up for the retrial, they've lost all their money, and now they're stuck with a public defender for the second trial.
And all their best strategies have already been revealed, and they got to try to do something new or persuasive. Meanwhile, the state still has the ability, the power, and endless resources to go out and try to dig up more evidence, so that asymmetrical balance, which is no balance at all, but the asymmetric nature of the criminal system versus the civil system, where the state has all the resources and power, and so the defense has more procedural safeguards to kind of compensate for that, to make it an even playing field, to the extent that a sovereign can have an even playing field with one of their citizens. But that balance is thrown completely out of whack on the second trial, when someone's already expended all their defense strategy and monetary resources, and so from that side of the retrial question, I think that it definitely favors the prosecution. And in this particular case, in the second trial, they admitted a whole bunch of other acts that were not included the first time. So that evidence that the state presented, and that was a question the Supreme Court ended up not deciding because of the grounds that they did reverse the case on. But in this retrial, the state had a significant advantage, even though I do believe that in most cases, a second trial can favor the defense, because you have a whole record of what everybody else said, and a skilled defense attorney, if there are resources to pay a skilled defense attorney, can use that first trial and everything that those witnesses said to prepare a better cross-examination, better direct examination, and really focus their message better the second time around. So I think this was like one of the unusual ones in which the state had a heavy advantage, but it's not always the case. It's just like with everything else in the law, it depends.
And you raised another good point there, that in the first trial, the judge didn't allow a lot of these other unrelated women to come in and testify that he had done this to them too. And in the second trial, the judge did allow that, and this was another ground that went up to the Supreme Court. And it's always interesting as lawyers, you do these appeals and you raise several different issues. And if the court can find that single linchpin issue that will dispose of the case, they'll focus on that and they'll say, yes, you've raised all these other issues. Let's just talk about this one. And because of the ruling in this one, therefore, we don't have to even consider any of these other issues. So that's kind of what happened here, was that they had a lot of different things to consider about whether that second trial was done fairly, but they ignored all that in favor of this one piece. So I want to talk also about kind of that interplay between the civil and the criminal. And Mari, you and I have done some cases that have related civil and criminal elements to them, and proceedings where if you know both systems, it works well. And if you know one system and you don't really know the other system, it can end up where you think you're doing something that's going to help and it really, really hurts. And that actually kind of happened
Right.
here.
I mean, it's a very interesting dynamic, the difference between the civil and the criminal aspects of things, especially because I don't think that most people realize they are as different as they are. And that includes most lawyers. I think a lot of lawyers don't really have a firm understanding of how different the two sides can be. But as you said, and as we were talking about earlier, really, the district attorney's press statement was aimed at removing Bill Cosby's Fifth Amendment right. So aimed at saying, now you can no longer take the Fifth. You're going to be testifying in depositions in this civil case. And that is what happened. And he sat for 4 depositions. And that was really his reliance upon that was where the Supreme Court kind of hung its hat in terms of deciding, not only are we going to reverse this conviction, but we're going to say that it's forever barred. But that's very interesting from a civil perspective because, as you and I had discussed, that taking of the Fifth Amendment can have very different impact in the civil realm than it does in the criminal realm. In the criminal realm, if you take your Fifth Amendment right, that's just it. You can't have a jury take any adverse inference from that. You have an absolute right not to speak and not to incriminate yourself. That's very different in the civil realm. In the civil realm, sure, you still could take the Fifth Amendment. And what could have happened here, had the district attorney not issued the press statement that he did, was Mr. Cosby could have been called to a deposition, could have taken the Fifth Amendment, and then, depending on how skillful his civil attorney was, his civil attorney could have turned around and used the adverse inference. And adverse inference is basically an instruction to the jury that we don't know what he would have said, but you can assume since he didn't say anything, it would have been bad. And sometimes that can be a lot more harmful to a party than what their actual statement was. So it really can make a huge difference.
That's absolutely true. Yeah, that's so true because, as a civil lawyer, if I were representing Ms. Constant at the time and the DA had said to me, hey, I want to do this so that we can take his Fifth Amendment privileges away, I would have said to him, please don't. Don't do that because, you could take that case to a civil trial and, you could have Bill Cosby up on the stand in front of the jury and say, isn't it a fact, Mr. Cosby, that you drugged her and you raped her? And he would look right at the jury and he would say, I plead the Fifth. And then the judge is going to look at the jury and say, because he pleaded the Fifth, you can assume that would have been a very damaging answer to him. And it puts you in such a great position where only one side gets to tell the story. And so, while it certainly looks like this DA was trying to, in a good way, trying to help Ms. Constant, in reality, he kind of took the handcuffs off of Bill Cosby's attorneys and allowed him to actually present a defense in the civil case.
Right. And as it turned out, the Supreme Court didn't necessarily view it that way because the Supreme Court did recognize that he was relying on the promise, and it certainly was a decision based on equity and fairness, which is obviously incredibly important to the justice system. But it's a very interesting aspect to it that really, had things gone differently, it might have actually worked out better for the victim in the civil case.
Yeah. Yeah, I mean, if he hadn't done that, it would have worked out better for in the civil case, and then there wouldn't have been this issue with the conviction potentially getting overturned.
Correct. Although, of course, you wouldn't have had the deposition testimony. So.
Yeah, and that's another thing is that the deposition testimony. Of course, I haven't read the whole thing, but it seems like what he said regarding this instance was that he offered her Benadryl, and she accepted it.
Right.
So, and he did make admissions about in the past, back in the 80s, that he had given women Quaaludes to kind of loosen them up. I don't think that he ever said that it was, unknowing, but, still, obviously that's certainly is, admitting to distribution of narcotics.
Yeah, and that may have been the more damaging of the admissions, really. Yeah. I mean, the Benadryl defense was essentially the same thing that he had told the police before any of this started. so that wouldn't necessarily have been impacted one way or the other by the district attorney's press announcement. But I think the references to previous women and the fact that he admitted to conduct with previous women was really damaging, particularly when in the second trial several of those women were allowed to testify.
Right. One of the things I found interesting, too, is that original district attorney who had made that decision, he moved on to higher political office, and then when it was announced that, his successor had opened a new investigation and was looking to prosecute him, it turns out he actually emailed her and said, hey, you can't do this. Don't forget, we had done this back at the time. And, interestingly, he actually said in that email, he kind of gave her a roadmap of, don't do this. Instead, go to his deposition. See if you can find some instances where he committed perjury in the deposition. And, if they had made this case instead a perjury case about during his deposition when he said that she consented, that was perjury, it's the same type of proof, but it's something that could have held up. And then I think the other thing he said was, although his statements were, binding on the state of Pennsylvania or the Commonwealth of Pennsylvania, that they weren't necessarily binding on other states, and that she might want to work with the California prosecutors.
Correct. And it was interesting too, because the district attorney who, he was emailing in that 10-year later email had been his first assistant and had been involved in the initial investigation. So, she certainly was present at the time that the press release was issued, but as you said, it was 10 years earlier, so.
Yeah, and that's one of the things that I really like about this decision, overturning the conviction, having nothing to do with whether he should be in jail or not. This court, had the courage to stand up and say that what the district attorney did was wrong and actually hold them accountable. And it seems like all too often you have appellate courts that say, okay, the district attorney did something wrong, but, it's harmless error. We're going to let it go. I remember very early in my career, I was involved in a big multi-defendant case, and there was, it was an Italian organized crime case, and there was a very clear violation by the prosecutors. And so we looked at the lead defendant, and it was his rights that were being violated. We said, why don't you take this up in an interlocutory appeal? You can win this thing. And he looked at us and he said, nah, I ain't gonna appeal this thing. Like, why? Italians make bad law. They think because I'm the boss of some family that they need to keep me in jail. So they're gonna come up with some new exception to the rule just for me. And ultimately, his reasoning was that although he could overcome this misconduct by the prosecutors, and ultimately he did, he didn't want to create an exception that would put all the defendants that came in after him at a disadvantage.
Right. Well, and that is a real issue in appellate work, as I'm sure Matthew would agree, that bad cases can make bad law all the time, and it becomes an issue for both sides, both the prosecution and the defense. But you're sort of looping back for just a second to something that you said earlier. The fact that one prosecutor did one thing, the next prosecutor didn't follow it up, and as you said, a lot of the time the courts will let prosecutorial misconduct go, is really why ethical conduct by prosecutors is so incredibly important. I mean, you wind up, especially when elections at this point, with people sort of espousing one sort of political viewpoint or another and trying to go down that route. And really what you need to be looking for a district attorney is somebody who is ethical and is going to do the right thing no matter what the right thing is. And sometimes the right thing is not popular, but that really should be at the center of every prosecutor's role, because there are so many protections for prosecutors. Most prosecutors are immune from suit. You can't challenge many prosecutorial decisions. It's extraordinarily difficult to do. And this was a very unique circumstance where the court was willing to, go out on a limb and do that. But because of that, it's so important to remember that ethical conduct is really at the center of that office. It's the most important thing.
Well, and you're right, because they are immune from civil suit. And while you can attack them in the criminal aspect, the prosecutor that made that decision will never be held accountable. And that's one of the things I've always thought about is you can improve the system a lot by whittling away at that immunity, whether for the individual or whether for the office. I mean, going back to what we were talking about earlier with retrials, if a prosecutor messes up a case and it gets remanded for a retrial, the defendant's still put into that terrible position of having to pay for 2 trials, and the prosecutor essentially gets the benefit of a do-over against a defendant with depleted resources because the prosecutor screwed up the first case. And I wonder, if they, change the rules to where the prosecutor has to then reimburse the defendant for all the legal fees expended on the first trial, what kind of an effect? Yeah, what kind of an effect would that have on the individual prosecutors, but also on the office? If it comes out of the DA's budget, then I would bet that the supervisors are going to be a lot more tight-reined on their assistants to say, make sure you're doing this thing right.
Yes and no. I mean, coming from the other side, they're coming from the other side before, there definitely are a lot of extenuating circumstances that can lead to a mistrial one way or the other. And yes, sometimes it is a prosecutor screwing something up. Sometimes it's something completely outside of that person's control. I think it would be kind of hard to have a bright line rule one way or the other. And I do understand that incredible amount of discretion that district attorneys have, that, there are good reasons for that. The reason for it is essentially that you don't want that person to be beholden to any political power. You don't want that person's decisions to be affected by anything other than what happened in this particular case. Is this someone who should be prosecuted? Unfortunately, in the real world, it doesn't always work that way, but that's the concept behind it. And I think it's a good concept. So, I'm not troubled by the idea. It's more just seeing it in execution sometimes, that ethical boundary is so important.
Yeah.
Let me ask a question about, just get your opinion, both of your opinion, as more experienced attorneys with juries. When we're talking about retrials, after there's been a hung jury, and we allow the state to retry that, right? Because we have a right to be convicted only by a unanimous jury.
Right.
But a hung jury that results in a mistrial, it doesn't bar double jeopardy because they allow that retrial. Does that, in your opinion, kind of the double standard about you need a unanimous jury to convict? You must convict on every element beyond a reasonable doubt. We have reasonable people on the jury who have been accepted by.
Hopefully, you have reasonable people on the jury.
they've been vaudired by both sides, vaudired in the north. They've been interviewed by both sides. The jury's been selected. The judges approved them, sworn them in. They sat through the trial. So we presume that they're reasonable members of a cross-section of our community. When reasonable members have a reasonable doubt, even if not all of them do, we don't have a unanimous jury, and we don't have a conviction beyond a reasonable doubt, but we still let the state have a second bite at the apple. Like, when it comes to those principles, how do you think we should handle that? Is that somehow kind of like a mistake in our system where it doesn't line up? Like, how do you reconcile that?
Well, it's difficult because how did the vote come out? It's supposed to be secret. We're not supposed to know. I've seen some reports, leaked reports that from Cosby's first trial on one of the counts, the vote was 11-1 for acquittal.
Mm-hmm.
So as a defense attorney, I look at it and I say, yeah, if somebody has a reasonable doubt, then that's a reasonable doubt. You look at, for example, in the UCMJ, in the military system, you don't need a unanimous jury there, and they don't have hung juries. You need
Right.
to have you need to have a certain number of jurors, to convict, and if you don't have that minimum number, even if the majority say convict, because you don't meet that supermajority, you have an acquittal.
Right.
Of course, the flip side of that is you then can have convictions for capital cases, with which are not unanimous. So it's not a perfect system, and it's difficult to get that balance. A friend of mine tried a case years ago, where it was another organized crime case, and as defense attorneys, we always say, to convict, they need 12, but I only need one for a hung jury, because oftentimes the prosecutor, sometimes they retry it, a lot of times they don't, and so he was a big proponent of they need 12, I only need one. And in this case, the jury was hopelessly deadlocked, 11-1, and then the prosecutor brought in information that one holdout had been bribed. And so the judge kicked that one juror off the panel and went forward and had an 11-0 unanimous verdict for conviction. And so my friend told me afterwards, they go in the back and the client looks at him and says, "You got to be the stupidest lawyer ever." I said, What do you mean? The whole time you keep saying, they need 12, I only need one. They need 12, I only need one. I got you one. If you told me you needed two, I would have gotten you two.
So my answer to your question, Matthew, is kind of going back to what Tim said while you were talking, which was hopefully. There are so many reasons why jurors make the decisions that they make, and sometimes they're based on the evidence and the law, and sometimes they are not. And you do, certainly I've seen many cases where it's been a hung jury because of one person in the jury room who just refused to deliberate with everybody else, and it had nothing to do with the case. Could have been anything else that was going on in their lives. So I'm not troubled by the concept of a retrial, and that is, another one of the things that's sort of one-sided in the system. If, on the other hand, you have, an acquittal is something that you can't ever say, like, oh, well, I didn't like that first 12 jurors. Let's see if we can do this again.
Right.
An acquittal is permanent. So I do think that that jurors. So I have this very unpopular viewpoint. I actually think the jury system does have a lot of problems. It's not a bad system, but it does have some issues. I really think it would be fantastic if we had a professional jury system. If it was a job, you can be a baker, you can be a taxi driver, you can be a juror. You'd have a large pool of people. You wouldn't have people trying to avoid jury service. You wouldn't have people lying to get out of jury service, which people do all the time, unfortunately. And they would become, as they gained more experience as jurors, they'd become better at evaluating credibility, evaluating evidence. They'd have a better sense of what was going on. I really think that system might wind up being more fair to both sides. I realize I'm alone in that. I'm not expecting it to happen, but that's, since you asked, I'm throwing it out there. I think a professional jury system would be a great idea. So
that's fascinating. I've never really contemplated that, but it's interesting enough that I'm going to be thinking about it for sure.
I've converted a few people.
Yeah, I have a lot of immediate reactions, but I would want to think about that and read up on that some more, because that's an interesting idea. One thing that you mentioned that I want to ask about to both of you too, you mentioned, juries can decide things for all different kinds of reasons. How important is it for high-profile clients to, or even high-profile crimes, even if the client themselves isn't high-profile until the case, how important is media strategy in making sure you have a legal team that knows how to handle both the ethics and, the effect that it will have on the case and the jury pool or the judge or whoever's making decisions.
Right. Well, this is obviously something I've had a little bit of experience with, and the rules state that attorneys are not allowed to make any extrajudicial statements that they may reasonably believe will have an impact on the jury pool. So, the media strategy, you have to be very careful because you don't want to have any impact on the jury pool. In fact, a lot of times you lose a lot of jurors in the voir dire process, or voir dire if you're in Texas, because they have seen the news reports. And when I was trying the World Trade Center base jumper case, I lost a lot of phenomenal jurors because the video had been so widely seen. And half my jury pool, they walked into the courtroom and they said, "Oh, Judge, I saw that video. That was awesome. I think these guys are great." And all my best jurors walked out the back right at that moment. So, but at the same time, the exception to the rule, because a lot of people only think about that first part of the rule. And the next part of the rule says, however, an attorney may make any statement that they deem reasonably necessary to counter recent negative publicity that was not initiated by the lawyer. And so, this is something that I've had to use many times when, the prosecutors, of course, they always come out with their press release of saying, all the terrible things that this person allegedly did, and having the video of the perp walk and all that stuff. And then, even though that's the only thing the prosecutor says officially, they then go off on the side and start leaking, more anonymous stuff to the press to try and influence the jury pool. Of course, they never get held accountable for that, but
ethics again.
Exactly, ethics again. And so, when I encounter a situation like that where there is all of this negative press put out by the prosecutors, then you do need to defend your client in the court of public opinion. In fact, there's even been a Supreme Court case law where the Supreme Court held, it wasn't the main holding, but it was part of the decision where they said, that an attorney does, your duty to your client does not end at the courtroom door. And you do have a duty to advocate for your client in the court of public opinion as well. There's so many aspects to that of everything that you're doing is being watched by the jury. And so I always tell my clients that, from the moment you get up and leave your house or your apartment in the morning till the moment you get back in at night, you have to have your game face on, because you never know. We're taking a lunch break, we're at a restaurant, and the client is sitting there laughing about something, and a juror just happens to walk by and think, wow, we just heard a morning of pretty horrific testimony, and here's the defendant laughing about it. He must not take this very seriously. So it goes much further than just the media. And of course, it becomes all the more difficult when you have a client that becomes part of a political movement. The timing of Bill Cosby's case, in the Me Too movement, makes the trial portion all the more difficult. Makes the appeal all the more difficult. Makes the appeal, in my opinion, all the more courageous by the judges that they did hold the standard in this case, notwithstanding the public opinion.
Right. I want to go back to the anecdote that you were telling about your client, who didn't want to make bad law. Because that goes back to another ethics issue that lawyers face, especially when it comes to possible political movements or making bad law. Like, very few appellate attorneys want to argue a case that has a high likelihood of making bad law. We want to make good law. But at the same time, when we're representing clients, our duty is to our client alone, and we can't have any care in the world for whether we're making good law or bad law, if the goals of the client are being represented. So it's very odd and also very neat that your client was so aware himself that, like, this is my goal, I don't want to do this, because as lawyers we serve the interests of the client. And so that's like one of those rare occasions where the appellate attorney doesn't have to kind of deal with the internal conflict of interest from maybe not advocating fully for his client because he doesn't want to make bad law, instead of setting his personal agenda aside and advocating for what's best for his individual client in that case. Because that's something that I think everybody looking for an appellate attorney or anybody else should be aware of is this attorney the best fit for me? Are they going to zealously pursue my interests as opposed to their own? And if we disagree on issues like whose interests is he going to be representing, because everybody wants to have their attorney in their corner because that's what they deserve. That's our role.
See, now the interesting thing is, in my experience, because I've done quite a bit of criminal appeals too, and it's actually had the opposite effect, because when I sit down with the client to evaluate their likelihood of success on appeal, I go through it and I say, okay, the ones that are probably going to make bad law because they're going to lose, I'm very upfront with them. This point here, you are likely going to lose. It's not going to be successful. And because I'm a private attorney, this is how much it's going to cost you to do something that I'm already telling you is likely to lose.
Yeah.
Whereas there are plenty of attorneys out there that, their personal interest versus the best interest of the client, they'll take up that case that they know is going to make bad law because they're just trying to get a fee. Oh yeah, pay me. We'll argue this. We'll argue that. We'll throw everything up against the wall and see what sticks.
Yeah.
And so I think that a large portion of attorneys that have that conflict, they create the bad law because they put their personal interests ahead of that of their clients, because they should be very honest with the client about what is your likelihood of success, what is your appetite for risk, what is the best way to expend your resources. Because don't forget, a lot of clients, by the time they get to a criminal appeal, they're in jail.
Yeah.
They have a family on the outside that was depending on them.
Yep.
And so in those circumstances, a low percentage appeal, to do a low percentage appeal literally is taking food out of the mouths of their children.
Yeah, agree with that. Some have the resources where they can just say, but for most, that's not the case at all. Most, it's a last-ditch Hail Mary, and if it's going to be a low percentage, that could very well be spent preparing for parole or probation, something, re-entry, which is its own difficult nightmare after the sentence is over. I think that's one of the most important things that a criminal appellate attorney can advise potential clients on is, here's all the things that you're going to face in addition to the case, the time that's going to have to be spent doing time or whatever on the conviction is, despite the low chance, here are all the struggles to come, even if we win. And so if you have this for resources and that's all you have, then you might be better on down the road preparing for parole, probation, to get out sooner, to make re-entry easier, or to take care of family members in the here and now instead of gambling, because there are so few successful appeals. Like, just as a matter of percentages, like, our courts get it right more often than not, and even when they don't, the appellate courts are often very reluctant to reverse lower court judges, except in, when you've got courageous appellate judges who do the right thing, even when it's unpopular. Like, that's what we all hope for from our appellate judges. But there's never any guarantees in any criminal case, and especially the further from conviction you get, the harder it gets.
Yeah. And one of the interesting things there, you talk about where your resources better spent. Look at Bill Cosby. Yeah, his sentence was such that he was going up for parole boards, but he was not going to get parole because he was not going to accept responsibility.
Right. And that's a unique catch-22 for sex offenses.
Right.
Yeah.
And I've had clients like that where, because their sentence is short enough, they can get parole faster by just admitting what they were convicted of, accepting the judgment, mea culpa, and getting released versus maintaining their innocence and continuing to push the appeal.
Right.
You don't have to necessarily make an affirmative statement of I am innocent, but you push the appeal in the hopes that it gets overturned, and if it does get remanded for a new trial, at least you haven't gone to a parole hearing saying under oath, hey, I'm guilty, I did this thing, because, you can win the appeal, go back on a remand, and then have your confession as Exhibit A, so... Well, so the Cosby case, it raises a lot of very interesting legal issues, and it certainly does show the interplay between the civil system, the criminal system, the Fifth Amendment, and prosecutorial discretion. So, all right, so do you guys have any final thoughts on this issue? Matthew?
I think, when we go back to talking about courageous appellate courts, I just want to kind of go back to one of the lines in the opinion, and whether Mr. Cosby is innocent or guilty, we have procedural systems and rules in place to protect our fundamental freedoms. And in this case, somebody who was guilty may have escaped penalty given by a jury, but that's for the protection of all of us, because we never know when we may be the one wrongfully convicted. And one of the cornerstones of our system is it's better that better that 10 guilty men go free than one guilty man get locked up. And so that's why it may seem so intuitively wrong when big cases like these are overturned and reversed, when everybody felt like finally there was some justice done in a high-profile case like this. But those appellate rights are there to protect all of us.
Yeah. Mari?
For me, I think a lot of it was just looking at how lengthy the opinion was and considering how tiny the soundbite becomes once that gets reduced into media coverage of it. And I'm just looking at this podcast, we have talked about some things other than the Cosby opinion. Certainly we've talked about some broader issues, but it takes a lot of time to really do an in-depth examination of really any criminal case, and in particular one of this kind of complexity that spanned literally decades, and that just gets erased so often in the coverage that people come across on a regular daily basis. If I hadn't read the opinion, which was quite lengthy and quite detailed, I would have very little sense of what had gone on, other than Bill Cosby did something bad and now he's not in trouble for it anymore. And that's there's so much more complexity there, and really what the court did was, in the end, weigh everything and come up with the equitable decision in this particular case, because it was a case where Mr. Cosby had relied in good faith on what the district attorney did, and that reliance was why he took the actions that he took, and things went forward from there. But without having all of the background that's in that decision, or much more in-depth awareness of it than most people are going to have, it's very hard to bring that across in just a 10-second soundbite. So for me, that was a lot of just the reminder of the complexity of the issues that are involved, and the way that complexity just gets lost so often. So I really appreciate having this chance to come on and kind of hash some of it out with the two of you.
No, and you're both absolutely right there, because I've experienced this so many times where a complex case gets distilled down to a soundbite or a tweet that can't even begin to accurately reflect what actually happened. And Matthew, what you said is also true, because this system requires equal justice. And there's so many times where you sit there and say, well, this person's guilty, so we should just just let it go this time. And to tell a quick story, I had a client years ago who was absolutely guilty, and I was trying to convince him to plead guilty because it was in his best interest, and he refused. And he said, "No, I wanna get the discovery, and I think you're gonna find something there." And I got the discovery, and I looked at it, and I thought, "Oh my gosh, here it is, clear police misconduct." And I can get this evidence suppressed and have this terribly guilty person go free. And I sat there and I thought about it, and I said, I could just mail it in, because this guy really needs to go to jail. But then I kind of stopped myself and I said, you know what? This is probably one of the most important cases for me to do this, because if I begin to choose, which clients you fight for and which ones you don't because of, what I think of them, the moment that the people who are supposed to administer the system start treating people unequally like that, that's when the system, truly breaks down. That's when I need to go find a new line of work. So I went forward with the, with the motion. I thought it was a winning motion. The judge, luckily or otherwise, disagreed with me. I believe I was right on the law, and I think the judge recognized I was right on the law, but I think the judge thought that my guy was guilty as hell, so he was going to go for the exception to the rule. But that's absolutely important. We have to do that, for everybody, because just because we don't like the result today, if we create a new rule based on the result that we want today, then tomorrow that could be misapplied to give you a result you don't want for somebody that's truly innocent. I want to thank you both for coming on here and giving your thoughts on this, and hopefully our viewers find this interesting and thought-provoking.
Thank you.
Thanks for the invitation to come on. It's been fun.
Absolutely.
All right, thank you. This has been another episode of the Pure Legal Guidance Podcast by Parlatore Law Group. See you next time.
The views expressed by both attorneys and guests of this podcast are their own and do not necessarily represent the views of the firm. The information presented here is for informational and entertainment purposes and is not intended to constitute legal advice or to replace a consultation with an attorney. Listening to this podcast does not create an attorney-client relationship. For advice on your individual situation, contact us to set up a consultation.